Paul Okonji, and I'm from Lagos, Nigeria. I'm a legal practitioner. I work with the law firm of Adebaton, Castle Martin, Blackburn, Sherman. You can call it Acres Law for short. I know that's a mouthful. Um, Acres Law is one of the leading corporate and commercial law firms in Nigeria. It's one of the top five. Um, it's boasts of about a capacity of 60 lawyers, and we operate in the three major commercial cities um, in Nigeria, mainly Lagos, Abuja, and Port Harcourt. That's where we have offices, but all our lawyers are qualified to practice all across Nigeria. Um, I'm not one of the speakers, so I'll try not to take too much time. I know a lot has been said already about the about mergers and acquisitions, so I will just say a few things from a Nigerian law perspective on mergers and acquisition. And the first thing I would just like to point out is, so basically I will just give a brief background on what the legal regime looks like. Then I'll talk about deal structuring. Um, then I would just touch on some of the key areas that we would usually look out for, the naughty issues. So in terms of the legal framework, broadly speaking, I would say the legal regime can be divided into two. You have the statutes that are usually of general application for almost all companies. Then you have some legislations that are sector specific. Now, for the ones that are of general application, the main law is actually the Investments and the Securities Act. That generally regulates how mergers and acquisitions are done in Nigeria. Then you also have the Companies and Allied Matters Act. That is the principal enactment that governs the incorporation, regulation, and administration of companies in Nigeria. You then for the sector-specific ones, they are there's a long list depending on the sector that you're looking at. You would have acts like the Banks and Other Financial Institutions Act if you're looking at an M&A in the banking sector, the Insurance Act for the insurance sector, um, the Central Banks Act, CBN, Central Bank of Nigeria's Act, and now recently earlier this year, the federal government also passed into law the Federal Competition and Consumer Protection Act, which has now been, it's sort of an interesting thing because traditionally we had the Securities and Exchange Commission which regulated mergers and acquisition in Nigeria. But this and its key role, one of the key issues that it looks out for um, competition and monopoly issues in mergers and acquisition. But the law has gone ahead to create a separate and a distinct legislation to regulate M&A, and has also now created a Federal Competitions Commission, which is now charged with some of the responsibilities that were able to carried out by the SEC. At this point, both the SEC and the Federal Competitions Act are working together. We're pretty much at the transition stage, so the deals are still filed with the SEC, and joint regulations are being released by both of them, by both agencies. Let me go quickly to deal structuring. So basically, most of the M&A deals are either structured largely as share deals or asset deals, and in some few cases you find a little bit of maybe assets being hived off into a separate entity, then a share deal being done. But those are just structuring issues which vary from transaction to transaction. So broadly speaking, the principles that govern the whether you prefer to do a transaction as a share deal or as an asset deal are that number one, there are no capital gains tax on sale of shares in Nigeria. So when you transfer shares and when you sell your shares, you don't pay capital gains tax. Similarly, but for asset deals, you get to pay capital gain tax at the rate of 10%. Also, for share deals, the stamp duties, you don't also, it's at a nominal rate. But for transfer of assets, it would depend on the type of asset being transferred. The rates are, for some cases, it's nominal, for some cases, it's ad valorem. For example, for vessel related transactions, it's usually ad valorem. Um, so there's been a lot of, as you know, Nigeria is the largest economy in Africa, and of course there have been several mergers and acquisitions derived from the days of the banking regulations in the early 2000s. And up till recently, presently the same thing is recapitalization is going on in the insurance sector. So there's also a lot of insurance companies trying to meet the deadline. So there are a lot of transactions as per M&A are happening in that regard. So we've also witnessed some of that in the telecom sector. We've also seen very interesting things happening in the banking sector recently. Some banks that were presumed to be not so big or small, we've seen them swallowing banks that were presumed to be large ones. So that just shows you that gone are the days when you would typically imagine that M&As are the smaller, the bigger guys taking up the smaller guys. We're seeing miracles happen in the Nigerian sector. There's a particular bank that I would like to mention. It's called Access Bank. At some point, some years back, it's acquired Intercontinental Bank, and recently it's done the same thing with Diamond Bank. And this were by no means small banks; they were pretty much large banks. So that would bring me to the next issue, the key issues that I would just like to quickly touch on as far as M&As are concerned. And number one will be corporate governance. We can't stop talking about corporate governance because we see a lot of things happening. And for example, the last example I just gave is a clear case of what is possible when you don't adhere to strict corporate governance standard. When you don't adhere to corporate governance standard, you would see miracles like the one I just gave happen, where companies who are presumed to be small, would practically take on the bigger ones and acquire them because they've not been above board. Recently, there's also an interesting issue with one of the top. So all the things I'm saying is public knowledge, so I believe I can speak freely about them. They're all in the media. Recently, there were sanctions on one of the top leading indigenous oil and gas companies by the SEC, also relating to issues of corporate governance. They basically sent them a letter after undertaking an audit, I think, by Deloitte, and they basically imposed sanctions on them, including demands that some top executives should relinquish their position, which also included one of the major founders. So the next issue I would like to talk about is capital importation. This is a very important issue. When you're investing in Nigeria, it is important that you consider how you bring in your money. And the regulations require you to basically import it through the authorized channels. And what that does for you is that when you're repatriating, whether you're bringing it as debt or as equity, at the end of the day, when you make profit, you're able to take it back through the authorized channel. So some of you may be aware that in recent times, or a few years back, there was this exchange rate issues in Nigeria, and so basically importing your capital through the right source at least gives you the right to come back to the authorities for foreign exchange. You know, when you invest and you earn local currency, so you're able to come back and transfer the funds through the authorized channels at the bank rate. So you also need to also consider where there's an M&A, if there's going to be a relationship with the holding company. Now, when you're going to have a relationship with the holding company, it's important that you look at the documentation governing that relationship. And in some cases where technologies have been transferred, you need to get some necessary permits and approvals. Also look out for employees issues. A lot has been talked about that. Environmental issues. If they're a minority, they have rights. They have to be protected. Issues of financing and funding. You have to ensure that Nigeria has rules against financial assistance by a company for the acquisition of its own shares. So you have to be sure that whatever structure you're putting in place, you're not breaching the financial acquisition rules. Then the last issue I'd like to talk about is the governing law and the dispute resolution provision. So Nigerian law allows parties to determine what jurisdiction they would like to have their dispute resolved, as well as the mode by which those disputes will be resolved. So you just need to sit down, think carefully about the appropriate jurisdiction where you want to resolve any issues that come up. So I would like to park the bus there for now. Thank you very much.